that. Okay, thank you. Super. All right, so we are solving problems already, but all we really need to do at this point is the Pledge of Allegiance. So, Director Morton, would you lead us in the pledge? Thank you. Our next order of business is closed session, and Mr. Giffen, would you tell us what we're contemplating there?
Yes, thank you, Chair. Members of the board and public, we will adjourn to closed session for items 3A, B, and C. 3A is conference with legal counsel, Government Code Section 54956.9A D1, the case of Resource Environmental, Inc. versus Fort Ord Reuse Authority, Monterey County Superior Court case number 19CV4499, pending litigation. 3B is conference with legal counsel, Government Code Section 54956.9A D1. That's the Fort Ord Reuse Authority versus all persons interested in the matter of the issuance and sale of bonds by the Fort Ord Reuse Authority and the tax increment revenue pledged to and to be used for the repayment of such bonds. Monterey County Superior Court case number 20CV381, that's pending litigation. And finally, item 3C, conference with legal counsel, Government Code Section 54956.9 D2, anticipated litigation, significant exposure to litigation. We have one potential case.
Thank you. Is there any member of the public who would like to comment on any of these items that we'll be discussing in closed session? All right, seeing no one coming forward, I'll close public comment. We will recess to closed session and come back as shortly as we can. I'm going to reconvene the regular meeting of the Fort Ord Reuse Authority. It's still Thursday, February 13th. And Council, would you announce any action taken in closed session?
Yes, thank you, Chair, members of the board and public. The board did meet in closed session on item 3A, conference with legal counsel, Resource Environmental, Inc. versus Fort Ord Reuse Authority. There's nothing to report out on that matter. 3B, conference with legal counsel, Fort Ord Reuse Authority versus all persons interested. That's the bond validation action. Nothing to report on that matter. And 3C, conference with legal counsel, anticipated litigation, significant exposure to litigation. One case was discussed. Nothing to report on that issue.
Thank you very much. Next, we will move to acknowledgments, announcements, and correspondence. Mr. Metz.
Thank you. By way of announcements, there's two here that I'm going to talk about. One is the Monterey Bay Economic Partnership 6th Annual Economic Summit will be held on Wednesday, April 29th at the Coconut Grove in Santa Cruz. And 4 days before FORA's lights go out, you're all invited to the Monterey Bay Drone Automation and Robotics Technology DART Symposium at California State University, Monterey Bay University Center. By way of correspondence, there's been two that have been received for the board and sent to the board this week. A letter from Landwatch addressing concerns around the HCP and the EIR process. We'll get in, and in particular related to an item before us, item 8D. So we'll get into addressing that at that time. And then there was a letter from Wellington Law Firm addressing concerns raised by Marina about the process of the motion on the ESCA EDC item of last meeting, and we'll get into that at the item 8A or 5A on the special meeting today.
Thank you. Let's see. Well, we'll do roll call, actually, next. Madam Clerk?
Supervisor Parker? Supervisor Phillips? Supervisor Adams? Councilmember Gagliotti? Councilmember O'Connell? Mayor Pro Tem Morton? Councilmember Hoffa? Mayor Oglesby? Councilmember John Wizard? Mayor Carbone? Here. Councilmember Steve McShane? Councilmember Garfield? Here. Councilmember Reimers? Here. Kathleen Lee? Nicole Hollingsworth? Erica Parker? Todd Muck? Dr. P.K. Diefenbach? Steve Matarazzo?
Here.
Dr. Ochoa? Jim Laughlin? Bill Collins? David Martin? Lisa Reinhardt? And Mr. Vander Mutton. You have a quorum.
Thank you. I'm going to, before we go into the consent calendar, I just wanted to let you know how the meetings are going to go today. So after we vote on the consent agenda, we will recess this meeting. I will call to order the special meeting of this board, and we will take up the items on that agenda. Also, and then we will return to this agenda. At this point, too, I'm just going to let you know that I'm going to pull item 8A from our agenda for this meeting because, and we will consider it as part of the special meeting. It's already on that agenda, and that way we don't have duplicate items on our agendas. So that's the plan. So fasten your seatbelts, and we will move now to the consent agenda. Are there any board members who would like to pull any items for question or comment? Yes, Director Adams.
I'd like to pull item 7B for a question.
Okay, 7D. Anyone else?
And boy.
Oh, 7B. B. Thank you. Great. And is there any member of the public who would like to pull an item for question or comment? Seeing no one coming forward, let's hear what the question is that you have on the administrative committee item.
So I was going back and rereading the past minutes from the administrative committee meeting, and I noted that I don't think that we have completed the successor entity designation, and it indicated that that would be coming to us at the February meeting, and I was just wondering when that is going to happen, because I know we need to have everything in order.
This is for the bond issue. Are you looking at 7AI?
Well, it depends on where you're looking.
Okay.
In the consent agenda, it was 7B.
He's in the administrative committee minutes, asking
yes,
which
you're
item.
correct. Yes, that's correct. Yes, 7I. Page 11 of the packet, I think.
Right, okay. Yeah, so that action needs to happen. We are planning to bring that, the thought is that we would bring all the bond documents back for a final approval by the board. The administrative committee has been consistent in its recommendation of the city of Marina on this role, and if you would prefer, we can bring it as a separate board item sooner, but we need to have the validation action approved first.
Prior to this.
Yeah,
Thank you. Thanks. Thank you.
thank you.
Thank you. With that, I will entertain a motion to adopt the consent agenda. Thank you. Motion by Hoffa, seconded by Gagliotti. Any further discussion? All those in favor, please say aye. Aye. Any opposed? Thank you. We will now recess the regular meeting of the Fort Ord Reuse Authority, and I'd like to call to order the special meeting of the Fort Ord Reuse Authority that was set for 2:30 on Thursday, February 13th, 2020. So I'm calling that to order, and Madam Clerk, could we have a roll call, please?
Supervisor Parker?
Here.
Supervisor Phillips? Here. Supervisor Adams?
Here.
Councilmember Gagliotti? Here. Councilmember O'Connell? Here. Mayor Pro Tem Morton? Here. Councilmember Hoffa? Here. Mayor Oglesby? Here. Councilmember Wizard? Here. Mayor Carbone? Here. Councilmember McShane? Here. Councilmember Garfield? Here. Councilmember Reimers? Here. Kathleen Lee? Here. Nicole Hollingsworth? Erica Parker? Here. Todd Muck? Here. Dr. P.K. Diffenbach? Here. Steve Matarazzo? Here. Dr. Ochoa? Thank you. Jim Laughlin? Here. Bill Collins? Here. David Martin? Here. Lisa Reinheiner? And Keith Vandermont. You have a quorum.
Thank you, Madam Clerk. I jumped right over acknowledgements, announcements, and correspondence. Mr. Metz, is there any of that for us in this
I
meeting?
can just reprise, you're all invited to the Monterey Bay Dart Symposium.
Fantastic. We will move then to business items. The first is a discussion of the nomination of the City of Seaside as the FORA successor and the EDC agreement, and I will turn it over to someone,
So,
Mr. Metz,
thank you.
to discuss this.
Yeah, Kendall Flint will be giving us an in-depth kind of background to get us all on the same page of what's happening, acknowledging our last meeting was left us a bit ambiguous at the end. So that's been part of the communication that we received from Marina, and the intention is to put extra effort into following process and being as clear as possible. Just by way of background from the staff and consultant side, since that January meeting, we've had numerous meetings with agencies and councils, all of you, your representatives, if not yourselves, and we have worked diligently to come up with a consensus document of agreement on this to really clarify what is being agreed to and understanding its significance to the region. So in the last week, we've had the document reviewed by the administrative committee on 2 meetings. There was a special meeting set the 6th of February where administrative members and their council were there. And the recommendation out of that meeting was to recommend approval of the agreement. This agreement was then brought to the Board of Supervisors on Tuesday and received unanimous endorsement from the Board of Supervisors. So I can just tell you, just from where I've been spending time, we've worked substantially, diligently to make substantial effort and refine and clarify and harmonize everybody's input here. So we hope that we're able to move this forward in a unanimous sort of a way. And with that, I'll pass it off to Kendall, who's going to give us a more in-depth background and set this up for your consideration. Thank you.
Thank you, Josh. As Josh mentioned, over the last several weeks, we've been meeting with all the jurisdictions and also with both special counsel and legal counsel, trying to find a path to agreement. One of the things I want to make sure that we're on the same page with, the direction that the board gave us at the last meeting was really to take some of the sections of the agreement that seem to be either ambiguous or not specific enough and try to clarify those so that there would be a comfort level for the folks, the grantees, to be able to support that. The idea here was really to clearly define Seaside's role as both the successor under ESCA, also for the local redevelopment authority, and of course as it relates to the economic development conveyance. The clarifying language has been laid out. We're going to walk through that for you all. And then one of the other pieces on this was a definition of what will be considered fair and equitable should there be future water allocations that would be available. And I'll talk about that more in just a moment. But first of all, I'm going to be walking through all of the changes that have been made. And I'm going to do it in a somewhat slow manner, I hope, so that I want to make sure everybody gets what we're talking about. We're hoping to be able to go through all of the changes and then come back for questions that the board may have. First of all, we have global changes to the document, changing it from economic development agreement to economic development conveyance. You'll notice a number of these things are to be consistent with other documents that are out there. We also have a global change from memorandum of agreement to EDC agreement. And then the third one was changing paragraph 2 and throughout the document to nominate Seaside as the successor to the EDC and LRA. And the reason for that is because FORA, in its power, cannot make that call. That call, at the end of the day, will be approved by the federal government, the Army. So FORA, in its capacity, this document is an agreement between FORA and Seaside to nominate them as the successor moving forward. Couple of places here that we had some questions, concerns. This is section 3. It relates to insurance policies. One of the questions that came up is there currently, it looks to be a gap in coverage between 2024 and 2028. Now, our special counsel is currently working on that problem to make sure that there is something in place, but in the agreement you'll notice that there is now language that basically says that Seaside's obligation would cease if no insurance was in place. These two things go hand in hand. Council is working hard on that. It's something that will not be finished in the next week or so, but it does not prevent us from moving forward with the agreement. In this case, everyone understands that the additional pollution legal liability insurance will be required from January 2025 through 30th of January 2028, okay? The next section has to do with no obligation of other entities. And one of the concerns that several board members expressed was what would happen to their local jurisdiction in terms of any obligation that is related to this agreement. So this section 8.4 clearly states that there is no obligation for any other of the other entities to bear any financial liability as a result of the ESCA contract. So that would be strictly between Seaside and, of course, the Army. These are the more interesting clarifying sections. This is section 9. And these establish some sections that came up again during conversation with concern. I think that the first one, of course, was water rights allocations. You may remember that last month we talked about fair and equitable. And let's just say that everyone had a different view of what fair and equitable might look like. So what we did is go back through all of the existing documentation as it pertains to water rights and develop a table that was supported again at the administrative level, and from what we've talked with other folks, it seems that we have consensus on that. This is basically carrying over the existing allocation by percentage that's already in place. You'll find that this also mirrors what's in the Marina Coast Water District's plan, and it's also what mirrors the TPIAs, which will be coming to you in another document. But these are consistent across everything, so that should, in the unlikely event the Army release water, however unlikely or positively likely that might be, the percentages would be as such. So if they release 100 acre feet, Marina would get 29 acre feet, and so forth and so on and down. And everyone seemed to be okay with that. As far as goes to wastewater discharge rights, this one was intentionally left as fair and equitable, largely because the administrative committee and others did not feel that we could actually put a number on it. But again, it would be a cooperative discussion between MCWD and the grantees, and it was believed that this, again, would be best suited for the agreement at this time. This section is section 3 of section 9, and this is actually just a call out to make sure everybody is completely clear about this. There were concerns about rights that are currently under FORA's jurisdiction that would not carry over to Seaside as a federal implementer. So in this case, no land use authority. That means for any of the parcels that Seaside transfers to the underlying jurisdictions, there's no reporting back for consistency determinations, there's no oversight on what the land may or may not be used for. The land is in the city's hands to do with what it wishes based on its own general plan or land planning document. So no land use authority, never going to happen. The fourth section of this regards payments. I'm trying to have a little lightness about this, and that was the next thing. Is like, what's going to happen with the money? It always comes down to the money. This again calls out: Seaside shall not require payments for any sale or lease proceeds or rents or any type of money that is collected based on the sale or use or reuse of these properties. You may know that at some point there was funds that came back to FORA. That is not the case with Seaside. So even though it's not in the agreements, we did call this out so that it's very clear and concise, and people were clear that they were not going to have to pay Seaside to use the property. I would like to point out, just as an aside, that if an agreement is not reached for whatever reason, and that property goes back to the Army, anybody who tries to get that property in the future would likely have to pay for it. And under this particular agreement, this is all a no-cost pass-through to all the jurisdictions that would be receiving property under this agreement. Section 20, I know how much the board really looks forward to getting a change the day of the board meeting. But this is a good one. This is basically a ministerial change that was made this morning based on some input from County Council and others, and it's really just the last line of this. So basically, the legal dissolution of the Fort Ord Reuse Authority, provided, however, that this agreement shall survive as to the grantees who are third-party beneficiaries of this agreement as set forth in paragraph 22, for so long as Seaside remains the successor local redevelopment authority. And what that basically says is that after all of these things happen, as it pertains to the transfer of land and that kind of thing, that you still have third-party status, which brings me to third-party rights also added. Third-party rights, the grantees are now having third-party beneficiaries of this agreement as it relates specifically to future transfers of property, water rights, and wastewater discharge. This all relates directly back to the economic development conveyance. These are the sections that we were asked to address, and these are the sections that were described in detail and vetted with, again, the admin committee, and were supported with the exception of section 20 that I just talked about, which came in this morning. So as Josh mentioned, the admin committee did recommend that the board approve this agreement at their meeting after a meeting on Wednesday the 5th and then a special meeting on the 6th. I also want to remind the board that the Army requires that the ESCA successor also be recognized as the Federal Local Redevelopment Authority. As far as the feds are concerned, these are connected and they cannot be taken apart, and they would be recognized under the Economic Development Conveyance Agreement. Just as a reminder, federal successor agency approval is required, and that's one of the reasons that we are looking forward to the 120-day processing at the federal level. I think the latest day to make a 120-day window without any room for error would be March 1st. So you can see we're coming right up against it here, which is one of the reasons why we want to make this a real priority. And again, failure to select a successor will result in the loss of those property rights and future water allocations. Should that happen, the property and allocations would revert back to the Army or federal government, and then it could be distributed at a later date through GSA or another mechanism. We are told that if that were to happen, you can be sure that there would be costs associated with acquiring that property, and there would be no guarantee of the water allocations that have been agreed to by these folks. So what we're seeing here in this particular package is the ask is to authorize the executive officer to execute the ESCA LRA EDC successor implementing agreement. And a yes vote would support nominating the City of Seaside as the FORA successor agency for all three of those pieces. And that's concludes my presentation, but of course I'm open as well as legal counsel and special counsel to answer any questions that the group may have. I do want to say again, thank you to all of you who made time to talk with us, sit down and meet with us, to provide comments and to provide your views so that we could perhaps craft a document that could be supported across differing viewpoints. And that concludes my report.
Thank you, Mr. Flynn. I just also want to echo the thanks to all the people who've been working on this since the last meeting. It was clear from our rather lengthy discussion at the last meeting that we were all very interested in finding a way to have Seaside be the successor on the ESCA and for the economic development conveyance, and the putting this language in place to memorialize what the duties and responsibilities are and the kind of the rules of the road gives me a lot more confidence that we've got something that it was the intent of this board. So I also want to express my thanks, and we did ask that a document come so that we would know what we were agreeing to. We had it in concept, but devils and angels can be found in the details. So I think we're closer to something angelic here. So I really appreciate all the work that's gone into that. Are there any board members with questions on this item? Director Hoffa.
Mine's really just a procedural question. So we had another motion that we approved last time. Do we need to vote on that, either up or down? And if we vote it down, then we could take up this staff recommendation. What's the procedural process?
Yeah, I mean, I can just tell you that when we put this agenda together, the understanding that we had was that we were very close, if not on point, for a unanimous kind of consideration. And so that's part of the reason we thought it would be simpler to not go back into the fog of the last motion. But it's really up to the chair if she wants to.
Okay, so we could just let that die and then take up a new one, or
so I think. Well, actually, I can defer to council, but I think the thought was to see the documents express the intent. They actually write down what we were trying to get to at the last meeting, but we didn't have anything ready. And so the thought is that if we can agree or mostly agree to this, then when we take the second vote, it's going to affect how we vote. We may not need that original motion that we now have a second vote on, but anyway, it's a little complicated, as things often are at FORA. So if council wants to take a stab at this, and we'll, because it's a good question. Where are we? What are we doing? And how does it fit?
I will say the normal process would be to take the second vote first, but given the hard work that's been invested in the process over the last couple of weeks, and given the discussion amongst everyone, it was, I don't think we can check our common sense at the door, given the level of confusion or difficulty we had during the last meeting. It was decided that we would put it in this order, and it's really up to the chair and myself as to how we structured it, and it just seemed to make most sense to do it in this order.
That way we know whether we have what we're voting on. So Director Morton, you had something, and then I think Director Carbone, did I see your hand? Right, exactly. Yes, you're there. Those are the options. So, yes, Director Morton.
Thank you. So the current draft that got circulated this morning has some additional changes, but to make clear, Kendall, is that this would be an agreement between Fort Ord Reuse Authority and Seaside for the Fort Ord Reuse Authority to nominate Seaside to be not only ESCA, but the local redevelopment agency as defined under federal law, correct?
Correct.
And that once designated, if the Army accepts, that Seaside would remain the local redevelopment agency, authority, excuse me, I'm going to call it the right thing, local redevelopment authority for an indefinite period of time into the future, correct?
I'm going to defer to council on that. I believe that their rights as the local redevelopment authority end when they have no more property left to transfer or water to transfer, but I don't know.
So that's one question that I have, because as I'm reading it, there's no termination. Second of all, as to paragraph 9, and I appreciate the work that was put in, that you've attached a table as to the current water rights. And I'm trying to make sure that this contract actually, as to paragraph 9, the subparagraphs therein particularly articulate Roman numeral I, Roman numeral II, triple I, and IV. When it's stating in those paragraphs that each of the, I'll just reference Roman numeral I and Roman numeral II. The statement starts, until such time as such allocations may be amended by agreements, comma, Seaside agrees to do X.
Mm-hmm.
Because those are subparagraphs of Roman numeral 9, where the entities, Seaside references grantees, are these subparagraphs about these agreements, meaning agreements solely with the grantees or agreements with any other agency in the world? I'm trying to make sure that this reference is to agreements with the grantees.
Correct.
And our legal counsel is indicating that that is the restriction.
Correct.
So the interpretation that we're giving this contract is that the allocations that set forth in Exhibit A remain in effect unless the grantees, being the jurisdictions identified, enter into some other formula that is deemed fair and equitable at any time in the future.
That's my understanding.
Is that legal counsel? Who's giving us a legal opinion?
George, are you on the phone?
I am on the phone. Yes, that was our intention in drafting the language.
Would it be feasible to...
Can you hear me?
Yes.
Yes, thank you. So would it be feasible in paragraph Roman numeral 9I and 9II just to insert until such time as such allocations may be amended by agreements with grantees, to insert the word with grantees before the comma in those two sections? Would that be something that could be done here at this meeting and be acceptable to our legal counsel?
It already states in consultation with grantees in paragraph II.
It says until such time as such allocations may be amended by future agreements, and it's agreements with grantees. I'm asking in that phrase, if the intention as to paragraph 9 has just been explained by Kendall and by our legal counsel, is the reference to grantees. I'm just making it clear, and that's the question.
We did vet this morning with legal counsel, and go ahead.
George, you're on.
Yeah.
I defer to others as to the procedural aspect, but I believe that would not change the meaning of the section. I would not object to that language as a contractual legal matter.
Okay. Thank you.
Over.
How are we making these changes? Is one person at a time? I would like each person to be able to ask their questions and then the group can coalesce around if we want to make those changes. But to go one person at a time, we'll be here to April.
So I think the
So I'm
idea is
asking
that there are questions being posed, we're getting answers, and after questions have been answered, we will then put together what from all of that we want to do. I think that's my sense of what's going on. And
That is, and I
Director
do
Morton,
have
do
a
you have another
couple more
question or two?
questions. So, one of the key questions that I had was related to paragraph 20, which had the contract terminate upon the closure of the Fort Ord Reuse Authority. And I appreciate that the language has been added to indicate that the grantees are third-party beneficiaries of this agreement. And I think the intention, and I'm asking legal counsel, is the intention there is to ensure that even though the contract terminates, the rights instilled to the third-party beneficiaries, the grantees, will survive.
Yeah, so that's the language.
I'm asking legal counsel, is that,
Yes,
so termination of a contract does not preclude third-party beneficiaries from suing or taking action to enforce and secure the rights promised to them under a terminated contract.
as long as the agreement so provides and the parties to the agreement so agree, they can have survivorship as they choose.
So the fact that the grantees...
In this case, I'm sorry, go ahead.
So the fact that the grantees are not parties, we would still, and FORA is gone, so Seaside would be the sole party, the contract is terminated, but the grantees are protected in being able to enforce their rights under this agreement.
That would be the nature of a third-party beneficiary of an agreement. The grantees are not parties to the agreement. They are beneficiaries of the agreement.
So then I'm looking to paragraph 20.
And they,
Please finish.
excuse me?
Please finish. I didn't mean to interrupt.
Oh, no, I was done. The parties to this agreement, FORA and Seaside, in the agreement have granted rights to other entities, in this case the grantees, with regard to the EDC agreement. And as long as Seaside is the LRA and is acting under the EDC agreement, then they would have rights. Seaside, of course, would always have the right to decide to cease being the LRA, and of course the Army could terminate the agreement. So when the EDC agreement terminates and Seaside ceases to be the LRA, then there would be no third-party beneficiaries of this agreement at that time.
So I have two more questions, and I thank you. As paragraph 22, the last sentence therein specifically contradicts the amendment to paragraph 20 in that it says, nothing in this agreement is intended to confer upon any individual or entity other than the parties and the above identified third-party beneficiaries any rights or remedies whatsoever. So that means it's protecting us. I'm a beneficiary, I'm a grantee as the city of Marina.
That was its intent. That others that may have desires to property or interest, they will not be able to use this agreement to secure their rights. Only the parties, FORA and Seaside, and the designated third-party beneficiaries will be bound by this document. Actually, the third-party beneficiaries are not bound. They are beneficiaries of the document.
Then the last question that I have is that paragraph 12 says, "This agreement or any provision hereof may be changed, waived, or terminated only by a statement in writing signed by the party against which such change, waiver, or termination is sought or to be enforced." My question is, when FORA ends on June 30th, 2020, this agreement is no longer capable of being modified, terminated, changed, so as to defeat the third-party beneficiary or grantee rights. Is that correct?
That would be my understanding, and I think our intention. The primary goal of this agreement is to make a nomination to the Army and OEA, and they would have to act on that nomination on or before June 30th. So after June 30th, if the Army accepts the nomination and Seaside moves into the role of successor, then the third-party beneficiaries would get their rights for the balance of that term under the EDC agreement. I do not see that there would be an amendment to this after that time.
So would it be feasible to paragraph 12 just to make clear that this agreement and the right to change, waive, or terminate this writing would cease on or before June 30th, 2020, which is the cessation date of FORA?
I believe that's implicit in the language already. Again, I'll defer to FORA as to a procedural, how they want to proceed with amendments, but that is my interpretation of the section. I defer to others if they disagree, but I would not object to such a change. I'd like to see the language, but...
So if in fact it's implicit, to make it explicit doesn't change the meaning?
Not in my mind.
Thank you for your help.
And I just think that the general rule should be, if we're not changing the meaning of the document, we can make changes, but I'd really encourage
Well, that's why I'm asking.
the board to minimize that today.
Director Garfield.
Thank you. That was really along the lines of what I was going to ask. I know that we've heard a statement that the Board of Supervisors has approved of this, and unanimously, and that the administration, the admin committee recommends approval, and I'm assuming that Seaside has done so as well. Am I correct in that assumption that Seaside agrees with this document as written? Okay. And so I don't feel prepared to say when we've gotten too far off of what's been approved, but how are we making sure that we're not undermining those approvals by nudging this language?
I think in listening to George Schlossberg and me, if we're going to change the meaning of the document, I think we'd get outside of the approvals. But so far, we've been, to me, well within it.
Okay. I just wanted to make sure we have a guard dog on that.
Yeah.
Thank you.
To respect to everyone, my point was asking the questions shouldn't change the document. Those were good questions that everybody asked. But just because something could be changed, something could be interpreted a different way, doesn't change the document. We should vote on this language in the document, and if there needs to be clarification, let the legal team clarify. But when you start going into could it change and are you open to a change as the attorney, then they're going to say, well, maybe if the board says so, and I want the board to have a first stab at it. If you guys want to change it, then we'll change it, but it's one right up here right now. Everybody had the language right in front of them. We should just, I know it's more questions, but my point is, we should just go ahead and take a stab at it and see where we're at and go from there. But that's how we're here at this point in time, because we had language. The language was changed. People didn't understand it. And I'm just trying to make sure we don't go down that road again. This is the language that everybody seemed to agree to. Let's take a stab at that when you guys are ready to vote on it.
Thank you.
Any other questions from board members before I open it up to the public? Yes, Director Wizard.
Thank you, Madam Chair. And more of just a clarification along the lines of the legal structure of the LRA status. There was a question about an indefinite period of time, and I'm not sure who the best person for this would be, but would it be more accurate to say indefinite or indeterminate? Because I thought at some point there would be a closure or a cessation of the LRA status, but I don't know if the LRA status has a specific, it has a shelf life, or if it is once a certain number of tasks are completed, which we cannot predict at this moment.
If that's a question for me, I'll tell you that in most cases, an LRA ceases to exist when all of the contractual obligations of the EDC agreement are fulfilled. In most cases, those obligations are fulfilled when all of the land is transferred. That would be a logical time if you wanted to terminate the LRA status voluntarily. However, the Army put language in here that talks about future interests, and I believe it would be in your community's interest to keep that LRA status open for as long as the Army retains any water, because that is a right that you have, and the moment you terminate your LRA status and terminate the EDC, you would lose that right. But that is what is very different about this LRA and EDC agreement.
Thank you. Any other questions?
One thing I would add is that after all the property is transferred, there are no obligations of the LRA. It can just sit on it just exists and sits on a shelf somewhere. And if the Army ever then decides it doesn't need water or wastewater, 5, 10, 15 years from now, I hope somebody will remember, pull the LRA status down off the shelf and go to the Army and say, I get it.
Set up the tickler system now. Yeah, right. Thank you. Any other questions from board members before I open it up to the public? All right, seeing none at the moment, are there any members of the public who would like to make a comment or ask a question about this on this item? Seeing none, I'll bring it back to this board for...
I'd like to make a motion, Madam Chair.
All right, please.
Okay. So I would move that we approve the written contract that is before us with 3 modifications. As to paragraph 9, Roman numeral I, that after the words until such time as such allocations may be amended by agreements with grantees, adding 2 words, with grantees. As to paragraph 9, Roman numeral 2, again, after the words until such time as such allocations may be amended by future agreements, inserting with grantees. And lastly, the amendment paragraph, which is paragraph 12, is that this agreement or any provision thereof may be changed, waived, or terminated by a statement in writing signed by the party against which such change, waiver, or termination is sought to be enforced, occurring on or before June 30th, 2020. If I would have a second.
I'd give a second, but on that number 12, you deleted what you just read, that the word only.
Yes.
Are you intentionally deleting the word only?
No, I didn't mean to.
Thank you. Second.
Thank you. And does the motion include the proposed addition of language in paragraph 20 that was mentioned? Was that included in our documents? I don't have it in my copy, but it was proposed to us.
So my motion is the revision, which included this language as a modification I got this morning. Understanding that the term of the agreement now reads in its entirety, paragraph 20, this agreement shall be effective on the effective date specified at the beginning of the agreement and shall remain in effect unless and until terminated by mutual agreement of the parties or upon the legal dissolution of the Fort-Ord Reuse Authority, provided, however, that this agreement shall survive as to the grantees who are third-party beneficiaries of the agreement as set forth in paragraph 22 for so long as Seaside remains the successor LRA. Thank you.
Thank you. We have a motion and a second. Comments on the motion. Director Gagliotti, then Oglesby, then Garfield.
Okay, so through the chair to Mr. Giffen, I want to get to yes on this, and if we can get to a unanimous vote and get this thing into Seaside's hand and off to the Army, that would be my ultimate goal here. Does anything that Marina has proposed, in your mind, are you comfortable with that?
I am personally comfortable, after listening to Mr. Schlossberg particularly, that the meaning of the additions do not change the meaning of the agreement in any way.
All right, okay, all right.
Seaside will not support any changes. If they don't change the meeting, then we don't need to add them. This was what the county voted unanimously on. This is what all of us agreed to before. So we won't be supporting that. And I'll just throw it in as an aside is every time you guys want to have a vote, if that's all I got to do, be the first one to make a motion to have you go through the process, then we can do that. This is how we got here before. These type of changes no one's seen, no one read before. But they made the first motion, and the chair gave them the say, and I appreciate that. But why are we even thinking about entertaining these things? Seriously, they have a right to make them, but at a certain point, are we going to move forward or are we not going to move forward? And so now this will not pass unanimously, and so when it comes back, right, now we have two of them that we have to solve. That's all I'm saying is after a while, we have to stop playing these type of games among ourselves. They have a right to say what they want to say, but we as a body need to move forward.
Thank you. I was actually going to say exactly what Director Gagliotti said, which is but I'm going to refine this building on Director Oglesby's comments. While you're saying this doesn't substantially or meaningfully change the agreement, these provisions in here, what is gained by it? What is the improvement that they offer, particularly from the perspective of Seaside? Because this is what we're doing. Is we're setting this up for Seaside. So what's the gain from these changes? And I would ask that perhaps Gail Morton, who's the maker of the motion, might have some clarification, and then council as well.
May I respond? The gain is that third parties have to read an agreement and understand it. So when our counsel is telling us that something is implicit in the meaning he as a legal attorney understands that, and that was the intent when it was drafted, the few changes that I've added are to make it explicit. So earlier when we talked about this document's going to go on a shelf, and 15 years from now, 20 years from now, is that to make it clear to the reader that the agreements are between Seaside and the grantees. That makes it clear for everybody on how the agreement was intended, which our counsel on the phone has just indicated that is the intention. I'm trying to make sure that it's enforceable and can happen. When you go to court on something, you can't, we're not going to call up this board meeting and have it viewed by somebody trying to read an agreement. We're trying to make sure the agreement says exactly what our intention is. Now, from the viewpoint of Marina and the other grantees, Seaside is on one side, but we have Monterey, we have Delray Oaks, we have the county. The intention here is that all of us are very clear in our understanding, explicitly clear, that we are the grantees and the intended beneficiaries of the provisions of paragraph 9, and that we remain empowered to get the benefit of the bargaining that we are contracting for today in voting to support this. So that's why I've made this motion, requested, and I really want to have our attorney address that the modifications are not changing the content. It is identifying explicitly what is our intention as a collective body.
Thank you. I appreciate your clarification of the motion, and I hope you don't take it that I'd like to hear from a neutral third party. Okay, so thank you. I'm going to ask this for. Thank you.
I would like to hear just from George as well. I think what we have is two changes, three changes that we're being told don't change the meaning of the agreement. I think we're there, but I would listen further to George if he has more input on the changes that are being made and whether they do modify or change the meaning of the agreement.
I'm the way I understood the motion, there were 4 changes. The change to paragraph 20 is in fact a desirable, it was a ministerial, I believe it was an oversight, in that the third-party beneficiaries were left out. So that was the one that was discussed earlier, and I believe was in the package that was before you or was handed out before this meeting. The other 3 changes, the changes to paragraph 9I, paragraph 9I, double I, and the change to paragraph 12, I do not believe are change the meaning. I believe that was the intent and the interpretation of those sections as they were drafted.
Director Wizard, and then did I see another hand? Yes. Director Hoffa, and then Director Ramers.
Thank you, Madam Chair. And so I guess my concern, I won't say it's rhetorical because then it doesn't require a response, but I'll say it's just on the merits. What is the virtue of adding non-substantive changes? What do we accomplish by adding more? So like if I said, hand me that green grenade on your desk, and I said, hand me that green foam grenade on your desk, there's no difference. You're going to hand me the same thing. But what is it? What have I added by including more information? We have 5 supervisors, multiple representatives from councils that make up more than a majority, probably a super majority, if not almost all of us in this room, who will vote on this thing. And I just don't understand what we accomplish by having all those people do that work and then come here and say, despite everybody getting together, the admin committee approving it and bringing it forward to the executive committee who approved to put it on the agenda, let's continue to tweak it. I just, so to that point, then I'll make a substitute motion that we just adopt staff's recommendation to adopt this agreement, the latest version of this agreement as presented.
I'll second.
Thank you, Madam Clerk. You have the maker of the motion and the seconder.
Just confirm second was Gagliotti?
Yes.
Yes.
Thank you. Director Hoffa and then Director Ramers.
So first of all, I just want to publicly thank the city of Seaside for stepping up and taking on this responsibility. So I think that's something that hasn't been said, and I think we should all be appreciative of them taking on this responsibility because it's a benefit to all of us. So number one. Number two, I'm concerned about the timeline. I want to make sure we move this forward. And, you know, I'm just worried about that timeline. It would be devastating if we don't, you know, if something happens and we got that June 30th deadline and the lands don't all get transferred. I have a comfort level with the alternative motion Mr. Wizard made because it has been overseen by the administrative committee, all of our city attorneys, the county's attorney, the city managers, and making, even though they might seem like minor changes, sometimes adding a word actually makes things more muddy. So our city attorney had discomfort with adding the word with grantees. Does that mean that all of the grantees have to agree? You know? So I appreciate the alternative motion. I'm going to support the alternative motion, and I hope that we can get unanimous consent.
I would just like to add that when we've been hearing the response from the attorney, he has actually reinforced the understanding that was presented to him in each case. So the language is sufficient in this document to answer the questions that were put to him, and I don't think the additional language is necessary because simply the questions were reinforced that they are accurate in their assumptions.
Yes, Director O'Connell.
Yes, as to the alternative motion, did that include paragraph 20 as stated on the screen, or is in the content of the staff report?
Madam Chair, the version of the document I have is on the table outside, and it has some underlined text in version 20, and so it's my understanding that's the most current version.
So it does include the changes that were made to paragraph 20? Okay.
Thank you.
Thank you. Other comments? Yes, Director Adams.
So I just want to get to yes. I really do. I feel like we played around with this for such a long time. And I hate it when we get to the point where you know, I just heard someone say, well, then Marina wins or then Seaside wins. This isn't a case of somebody winning. This is simply a case of just getting this done. But I want to point something out. With all of the brilliant minds that have gone through this and read it and amended it over and over and over again, nobody even commented on the typographical error that is in section 10, where it said Seaside agrees to execute an ESCA agreement and to comply with the U.S. Army Corps of Engineers. And I'm bringing
It's
that...
a two-step, you know, you have to do it
to
twice.
comply.
Yeah, boots and, you know.
But I'm bringing that to our attention because I don't think that the words matter. Whether we go for what Marina wants to do, or that language, or whether we go with what was original as the Seaside is bringing forward. The truth of the matter is, we need to get this done. And I am imploring my colleagues who are all around this table to please let's just make the typographical correction, number one. But number two, I just feel like we ought to be able to come to an agreement, and I swear to God, we've done this at the Board of Supervisors once, and we ought to do it here. Let's just flip a coin and then make the decision, and that's going to be it, because it doesn't make a difference one way or the other. It's the same language. It is the same intention. And you might think I'm kidding here, but I swear, I feel like we've kind of come to the end of our rope.
Through the chair.
Go ahead. You're right.
Now, I appreciate the supervisor. I was just going to ask, what did you guys flip a coin on, the budget? Or what coin was it? I appreciate what everybody wanted to say, but I just want to come back to the original thought here. The LRA and this language is not Seaside. It's not Seaside. The language you guys are talking about is the two lawyers, and we love our lawyers, from D.C., and our counsel here, and all of you managers and city attorneys and county attorneys weighed in on this. And of course, Seaside wanted to understand it, but if you guys vote to have Seaside be the LRA, we'll be the LRA, but it's not Seaside win, the region wins. You know, the region win. We just happen to be some people that have property that won't transfer by June 30th, so we need an LRA. And I appreciate Board Member Hoffa's comments, and I know a lot of you guys feel the same. I'm just saying, we don't win, and I know what you meant, but I'm just saying it's not ours. We will work for the grantees. This is your thing. And we should worry about the time, because we run out of time, and it reverts back to the Army. The Army's going to sell it to the highest bidder, and all of you guys talking about what you think should be there, well, just think about the person that bids the most money to get that land. You're not going to have a say. Well, county may have a say, but most of them won't have a say about what goes there, and then we all lose. And you know, so I appreciate your comments.
Just before we go to you, Director Carbone, it looks like Kendall Flint would like to get a word in edgewise.
Thank you, Chairman. I want the board to be aware that this document was initially circulated 2 weeks ago. And then in the course of all these different meetings, that one of the meetings was specifically with admin, where we had the councils from the county, Monterey, and from Seaside. And as you may guess, when you put attorneys in a room with other attorneys, sometimes they agree and sometimes they do not. But I will tell you that as we went through this process, that we went through a painstaking level, and when I say pain, I really mean painstaking level of detail on these things. So I'm not either encouraging or discouraging anything, but I'm just saying we did this, they supported it, they agreed, they moved forward. I'm concerned that at this point, having looked at the face of the city attorney from Seaside and some others, that edits at this point may be counterproductive to your end game.
Thank you. Director Carbone?
Yes, I'd just like to thank staff for all the work that they put into this. And right now, we have a motion and a second, and I would like to ask the chair to call for the vote.
All right. Any other board members with comments? Yes, Director Morton. Sorry, you had your hand up.
Yes, so while I'm listening to this representation, Kendall, that you just indicated that we had an admin committee meeting with our city managers basically representing our jurisdictions, and that there were some attorneys there. Yesterday afternoon, I contacted you personally and pointed out that the agreement had a termination date of June 30th, 2020, and did not include the reservation of rights for the beneficiaries. So regardless of who's in the room, points get missed. And the clarifications that are being asked for in the language that I've put forth in my amendments are to ensure that the interpretation that is being discussed in this room today, including the preservation of rights for the grantees as third-party beneficiaries, is included in the document. So to say it was perfect at an admin meeting is a misrepresentation to this board, and the language that's in paragraph 20 that is circulated came out of council, my understanding, for a council meetings this morning, because there was a defect that was brought forward by the city of Marina.
And the county and our own
secondly,
attorneys,
yes.
because they felt that it was a ministerial change,
Okay.
that it was not fundamental. I'm simply saying that this morning we did discuss with our council, and we did discuss with the City of Seaside's council, proposed changes that we received from Marina this morning, and we did discuss those, and it was, the discussion indicated that they perhaps would not be supported by the City of the City of Seaside, and brought us to some concern about whether or not they would be viable moving forward.
And one follow-up.
Mhm.
The suggested additions to the paragraph where we say with grantees, that wasn't what was reviewed this morning, but council now is indicating it doesn't change the meaning of the agreement.
Actually, it was reviewed this morning. Your council provided a letter this morning, I think we received it at 9 o'clock this morning, requesting that and a couple of other changes which were discussed. And we did review those, and we did try to find if we could have, consensus as we did with the number 20. It wasn't there.
Thank you.
Great, so there's been a request that we vote. Director Garfield.
Thank you. Just one more thing before we vote, because we can't undo the vote. It looks to me when I listen to this that we've got 2 no votes no matter which way we go. So I'm going to ask, is there anything we can change from Seaside or Marina's point of view that would get them to the middle of this discussion where we can all go forward with yes?
Well, I can't speak for Marina, but let me just give you a point of view. Is my understanding is most of this language, 99.9%, and maybe some changes this morning, whatever, was agreed to at the admin committee, except by Marina. So it seems like everybody's agreeing except Marina. So when you ask the question, is there something you could do to get Seaside on board? You're saying Seaside need to adjust to Marina's changes. You're saying we all need to adjust to Marina's changes. You're not asking Marina to adjust to the rest of us. So, well, but I don't know. My point is, as a board, everyone has a right not to vote or vote for what they want. Marina's saying they're uncomfortable with it. Why are we holding up all of this just because they're going to vote no? It doesn't have to be unanimous, right? Does it have to be? No. So, what are we doing? And so I'm kind of a little uncomfortable by someone saying, is there something Seaside can do other than Seaside acquiescing and agreeing with Marina? And again, Seaside is doing this for the region. We can't help, we have some land to transfer and, but we're doing it for the people that don't have land yet. That's the LRA, right? If someone else wants to volunteer, then when this thing first landed, I'll just take 30 more seconds. When this thing first landed, and respect to the county, my understanding the county didn't want to do it. My understanding is Marina didn't want to do it. That left us. That's 6-7 months ago, right? So to get down here now and say what should Seaside do to make Marina comfortable, I'm asking what should I do to make you comfortable? But you guys don't seem to be caring about yourself. You keep caring about what Marina wants. This is a regional body, and we should be acting regionally. This agreement will not hurt Marina. The agreement with the Army would not allow us to hurt anyone. So I'm trying to understand, what is the problem?
Marina is not advocating solely for Marina. You hear the word grantees. What I'm looking for is clarification to ensure that the contract extends to the benefit of all the grantees, which are each of the land jurisdictions, Monterey, Delray Oaks, the county, we have the 2 school entities in here, is that these grantees, we're trying to preserve and protect their interest and make clear that this agreement grants to them as third-party beneficiaries rights that are not terminated in the future, and making clear that there's a contract that ensures their rights are protected after FORA goes away. I would ask my colleagues at the City of Seaside, when our council, the FORA Council, who we as a collective board would be looking at for a regional perspective, when we insert words that don't change because the council has said, this is implicit, this is the understanding, this is the intention that was meant to be written. And I'm just asking for clarification by the insertion of a few words, except paragraph 20 did get changed, thank you, is what is the objection that Seaside has to the clarification if it's implied in the agreement, implied meaning the reader has to interpret and give it that meaning, but that is the intention, that you're just making it clear what is the objection to making what is our intention specific and clear.
Thank you. Okay. I think we may as well vote. So the motion on the table is, yes, Director Adams.
I'm still looking for something that can get us to a yes. Is it ever possible to just like add a footnote or add a side letter or something that would allow Marina to vote yes on this and then have a side letter that indicates the changes that they would like to see? So that we could at least vote on the language that's present here today?
I don't think that's the maker of the motion's intent.
Okay.
And I don't think that would work either. We're going to have it as the agreement as is with paragraph 20's changes or not. And right now, that's where the motion is.
Okay, thank you very much.
Thank you. So the motion that we have is that we approve the language that was submitted by staff, including the adjustment to paragraph 20, and we probably should have a roll call vote.
Director Oglesby? Just.
No, I vote aye.
Director Parker?
I'm going to vote no. I think it's important to have the language be explicit.
Director Adams? Director Phillips? Director O'Connell? No. Director Hoffa? Yes. Director Wizard? Aye. Director Gunter? Mr. McShane, Director? Yeah. Director Reimers?
Yes.
Director Gagliotti? Aye. Director Morton? No. Director Carbone?
Aye.
Director Garfield?
Aye.
Ten to 3.
Thank you. All right, we're going to move now to business item 5B, and I think there's a short presentation on this.
Well, you want to respond about the Wellington letter, or just recognize Gail's motion?
Yeah. We are going to go forward with the second vote as we customarily do after I think it was a 7-6 vote last meeting. We have received the letter from the Wellington Law Offices, which suggested that Robert's Rules of Order are applicable. It's true that the FORA board did adopt those, and it's appropriate to take a second vote as the motion that was made by Director Morton was motion made and seconded, and I believe there was a friendly amendment as well from Director Wizard, and you should go forward and take action on that second vote.
Okay, Director Morton.
So my question is a procedural question, is that this motion was made with regard to a contract between the Fort Ord Reuse Authority and Seaside to designate it to have FORA nominate Seaside for ESCA and for the Local Redevelopment Authority. So the substitute motion said, yes, we want to do that. It made a motion saying we're going to nominate Seaside as to ESCA and then as to limited scope for the Local Redevelopment Authority. 3 minutes ago, this board adopted or passed, didn't adopt, but passed a motion with a revised contract that replaced what was in the packet last month. So doesn't that action render a second vote moot?
I don't think it's been passed yet. According to the master resolution, it did not pass by a unanimous vote. Therefore, we have another vote to take, and until that vote is taken, nothing's been rendered moot.
Okay, thank you.
So, but I think Director Morton raises an issue, which is that this is what we were trying to do last month, the majority of us voted for it. Now we essentially, as I understand it, and please correct me because I'm part of the reason we got in trouble about this motion in the first place. So, but as I understand it now, we don't really need this motion. So if we, I guess, so our options would be, yes, the maker of the motion could withdraw it, or we could take a second vote and just, even though we voted for it last time, we could just vote against it and then it's gone.
I think there is the option that the maker of the motion could withdraw it, yes.
Right.
Chair,
And-
could we just continue it till next month? It has to be done in the second meeting?
I think you can continue it if the board is so inclined.
So as the maker of that motion, I would move that we move the second vote to the same meeting that's taking a second vote on what we just passed. I don't have the number. I apologize. Can somebody give me the number? 5? 5A. So my motion is that the motion for a second vote be continued to the meeting where there is a second vote on motion 5A that was just voted upon. If I can get a second.
Okay, there's a motion and a second. So I think Director Phillips and then Wizard and then Hoffa.
I think we go through and do it the right way and have the second vote. Otherwise, someone, probably Marina, will find some procedural problem with the way we did it this time. So,
Thank you, Madam Chair. I was just curious. Sorry, Director Hoffa's laugh is very infectious. I was curious to know if our executive officer and or authority council could opine as to what the value of tabling it is, since we're going to have the second vote on the thing we just did, presumably at the next meeting. We would have both of these things scheduled for the next meeting. I just don't understand why we would do that as opposed to just voting now.
I'm not an attorney, and sometimes I think that's a benefit, actually, because really, I think what I try to do in doing our negotiations and conversations with all of your all's teams and everything is to use plain, common sense language. And I would say, generally, it wouldn't make a whole lot of sense to keep this going. It would make sense to just have the vote here and end this and move on to the future, which is the second vote on the item that you've just debated for some time. But I'll leave it to the attorney if he wants to add any more legalese on that.
I don't have any more legalese to add. It's completely up to the board whether they want to continue it or not, or vote on it today.
Through the chair.
Yes, Director Wizard.
Thank you again. I'm surprised to hear that we could table it, because it has always been my understanding that a second vote happened at the next meeting. And I understand that we have Robert's rules and motion to table is an appropriate motion, but I thought there was some specific language in the bylaws or articles of incorporation. I'd just been, through conversation, I had just, that lives in my mind, but I don't have a specific reference to cite. So is there maybe...
There's no such reference. There's a practice that we would normally vote on this take a second vote in the next meeting, but it's the board's discretion.
Very good, thank you.
So I would urge that we vote the motion down and then take it up and vote down the original motion from last time. My thinking is the majority have made it clear we're not really interested in this, so why keep it on the table? And secondly, I think unless we take action to have the second vote and vote it down, it leaves it ambiguous what our intention is. Some entity, it could be a lawyer out there who says, oh, somehow you violated the Brown Act. We've had that happen before. Who will sue us? We don't want any kind of lack of clarity or anyone to say we somehow violated the Brown Act or did not, did something improper. So I just think the best thing to do would be to kill this.
I would just echo, I think, what Gail mentioned when she first brought up the question. This motion was on an agreement. The document, I think, is in the packet. It was incomplete agreement, and there's been significant work on improving the agreement. So doing anything on this motion is kind of, that's, yes. So just to do the process, to do the Brown Act, whatever, thing, just take a vote, vote it down, and move on. That's the simple move.
Right, okay, let me just, I'll go quick. But that's my point. All we're doing, and I appreciate the expertise, is using the Robert's Rules of Order, which is, hey, kick it down the curb, down the street. But you're right, Judge Phillips. All that means is someone gets us in the bind about how we're proceeding. This is still on the books. We have to have a second vote, whether it's a week from now or 2 weeks from now. So let's do it today. But they're using Robert's rules, and even to the point we had the executive officer come back around and say, hey, this is moot. Well, yeah, that's the whole object of kicking it down the curb. Let's just, now we have to take 2 votes to say no, so we can go to do something else. That's all that's happening.
So I was very confused about the last occurrence. Director Reimers and I sat and watched the video a couple of times, which is not nearly as much fun as it sounds. And I found that I really couldn't explain why I voted the way I voted. I felt terrible. And so I want to be absolutely sure I understand this time what my vote will do. So if I vote no this time, and other people vote no, so that the noes win, this is dead. Thank you.
Madam Chair.
Director Phillips, did you have something you want to say? And then Director Reimer.
I was prepared to make a substitute motion that we move forward with the vote today on the second vote.
Okay, there's a motion and a second to take the second vote today on this item. Director Reimers, did you have something?
No, I just wanted to clarify what we were going to be voting on, and now it is clear that we're voting on the second, which would be a denial of this vote.
We're getting there. Yes. So, yes, Director Cagliotti, did you have something you wanted to say?
Well, I just wanted to maybe clear, Director Reimers, is that we have a substitute motion to first get to that vote, and then we'll get to this.
No, the substitute motion takes precedence.
Oh,
The substitute motion is it.
oh, let's do that.
Okay, so I will just withdraw my motion to continue it. It
Okay.
makes sense to me in how FORA goes forward, and because I'm trying to make sure we're not moving backwards in what the written contract says. So I just thought it was much clearer, but that's how I think, and maybe not how everybody else does. So I'm withdrawing my motion. Thank you.
So there's no, you've withdrawn your motion to continue.
I'm withdrawing my motion to continue.
That
Go
was
ahead, do
and that
your
was
second
seconded
vote.
by Director O'Connell. Okay, that's withdrawn. So why don't we just have a new not a substitute motion, but a brand new motion
Starting again.
that would lead us. Yes. That's fine.
So we have a motion on the floor, or the table, or somewhere, out here in the air, that we take the second vote today on...
It's on the agenda. You don't need a motion to do that, because the agenda item is to consider a second vote. That you don't need to do a motion about. Now somebody needs to make a motion. It's just a second vote on this motion.
All right.
And so it's not a procedural change. What I had introduced was the concept of a procedural change, which I have withdrawn.
So the substitute motion goes away because you have withdrawn your motion. So there's nothing to substitute. Okay. So now we're back to our business item 5B, which is the second vote on the original motion. And Director Garfield had asked to know what a yes or a no vote meant on a motion. So, would someone like to clarify that for us?
I'm sorry, Chair. Go ahead. Point of, you know, we all want to play attorneys, right? Some of us had a career, some of us making a career out of it. But at a certain point, we need to turn to our paid attorney to settle some of these things, right? So I appreciate Director Morton telling us how to clarify these things, but that's right after the attorney said do something different, right? So let's not go so fast where we don't allow our paid attorney to give us advice. And we got in this confusion because we were talking to each other, so I'm just asking maybe he should be the one to clarify what a yay vote means and what the no vote means. I think the majority of us does, or do, right? But it shouldn't be me telling you. It should be the attorney being fair down the middle.
Okay. We ready? All right, okay. We have a motion that was passed 7-6 last meeting. As confusing as it was, and it left everybody in stitches. We have the motion. It was seconded. It was amended friendly, and it passed. We are now up for a second vote. A no vote would kill the motion. A yes vote would pass the motion. So if you vote yes, the motion that was made is passed. If the motion doesn't pass, or if you vote no and the majority prevails, the motion is dead. Okay. Does that make sense? Yes. All right.
My last question is, if this passes, that means the vote we have before is moot. So it took me a long time.
We have issues if this motion passes.
Okay.
Yeah. Isn't it great? So, this is a second vote, and I think it's, there's a question as to whether we open up second votes to public comment. And so just to keep life interesting, I'm going to ask if there are any members of the public who would like to comment on this before we vote.
Yeah, just to keep life interesting, yes. It's very interesting. The coin situation, obviously, Marina has a two-headed coin when it comes to prevailing wage. There's no winning on the side of the workers. Seems like it wasn't explicit enough what your duties were and such. And we'd certainly appreciate if your city manager would stop trying to destroy the working conditions and wages of people in this area. So anyway, now to move on to funnier stuff. Yeah, it's interesting.
We need to keep on subject, please.
Watching the conversation here. Thank you, Counselor. It's, I most certainly hope that we can move forward to get a good understanding of what's taking place here. I'm sitting in these meetings hoping to eventually come away with an understanding as to what FORA is going to be doing in the future, how land transfers will affect certain things and such. So anyway, move forward.
Any other member of the public wishing to comment on this second vote? All right, seeing none, I'll close public comment, and let's take a roll call vote on the second vote on the motion before us.
Director Oglesby? No. Director Parker?
No.
Director Adams?
No.
Director Phillips?
No.
Director O'Connell? Yes. Director Hoffa? No. Director Wizard? Director Reimers?
No.
Director McShane? Director Gagliotti? Director Morton? Director Carbone? Director Garfield?
No.
11 to 2.
Thank you. So that motion is defeated. Thank you. So we will move now to public comment. Any public comment on any item not on the special meetings agenda today? Seeing no one coming forward, I'll close public comment. Any items from members?
I wondered if we were going, oh, it didn't get called on. Yeah, I wondered if we were going to review the times for the special meetings, if there was going to be discussion
Yes,
on that.
so as soon as we end the special meeting,
Well, then we're going back to that
then
agenda.
we're going to go back to our regular
Thank you.
meeting.
This is
Yes,
so
I know. It's a two-step, yes, it's very, because we thought that it was a little too simple, just, our discussions weren't confusing enough just having a regular agenda, so we thought we'd better do this. No, so yes, we will come back to that. Any items from members before we adjourn the special meeting? All right, seeing none, the special meeting is adjourned, and we will now reconvene the regular meeting of the Fort Ord Reuse Authority Board of Directors. We are now on business items number 8. A has been withdrawn, and we will move to the draft transition plan implementing agreement update.
Yeah, so Kendall's going to do another a walkthrough on this one. This is an information item.
Right, this is extremely brief, but just to reiterate, on the next administrative committee meeting, we will be taking the TPIA update through in painstaking details, line by line. So we do encourage that legal counsel do attend if you can. We're going to be devoting the entire meeting to the TPIA. It's in the board package for your reference. Our goal is to basically get as much feedback and actually follow a path very similar to the development of the ESCA contract, so that we can get this out to have the agencies have an opportunity for comments. I think we set the deadline for return of comments by March 30th, so that we'd be able to, in fact, turn around a clean document that then can be put forward to the various councils for adoption prior to June. So it's just an oral report for today.
Thank you. Any questions from board members on the transition plan agreements? Where we are? All right. Any questions or comments from the public on this item? Seeing no one coming forward, we'll close that, and thank you for the update. We'll move now to 8C, the building removal bond status.
Yeah, so as we touched on a little bit earlier, but the validation action is open on this one through March 9th, and we have been to Sacramento twice to meet with legislators and agency heads to inform them of what we're trying to do. We are hopeful that there will be no major negative response to the validation action. We'll be meeting with tomorrow with the EPS and affected jurisdictions on the question of the impact to the fire district, and we will then convene a meeting with the fire district following the reception of that bit of information from EPS, and expect to resolve any issues there as possible, as soon as possible, and bring back any information here to the board. As we talked about earlier, there will be subsequent actions after the validation action closes that will be brought to the board as well. So is there any other questions?
Questions for Mr. Metz on this? All right. Any member of the public wishing to make a comment or ask a question about the bond validation action? Or okay, seeing none, I'll close public comment, and we'll move now to 8D, the consultant services contract amendments. Is that you again?
Yeah, that's
you
me.
Lucky
Yeah.
fellow.
Yeah. So we did receive a letter from Landwatch that called out raised concern about this item, and I think it's appropriate to address it here. There was a question about whether this was the proper time to consider the full amount of the proposed contract amendments. That subset of that dealt specifically with a policy decision yet to come before you about pursuing to completion the certification of the EIR for the HCP. And there's a fair amount of discussion on this matter happening at the Habitat Working Group. And so we have an option that we can put up on the screen. There's a summary slide, I think, that can go up there. Just go all the way to the end, will you there, Kendall? So we kind of broke out what is in the packet for you. The total amount for this item that's been requested is the $322,722. That's at the top. If you wanted to consider postponing the EIR related items, we broke those out there, and there are items that are related to maintaining our expert folks from DD&A to support the Habitat Working Group, and to obtain CEQA attorney specialist opinion on the question about the EIR, and to include another amendment to support continuing support of your executive officer by way of the RGS team. They've become pretty much our de facto subject matter expert staff and strategic advisory members. So that's what we have as the option if you wanted an option.
Any questions from board members? Yes, Director Hoffa.
So my only question had to do with kind of the process of contracting with CEQA attorney, and I wonder if maybe you could explain sort of the rationale for having a contractor kind of in essence subcontract the legal services, and why our city attorney has some concerns about attorney-client privilege in that instance, and also just in essence who's giving the direction to the CEQA attorney. So what is the rationale and the benefit of kind of doing it this way?
We had the same question initially, but then I felt like we were in the business of closing contracts, not opening new contracts. So that was kind of my initial thought. Also, there has been some preliminary engagement with this particular CEQA attorney, which provided a conflict of interest assessment that was done with regard to working for DD&A, and that would be a bit of a time-consuming element to get done with all the multiple jurisdictions represented here, and that there's a time kind of a sensitivity on this one, where the question about the legal exposure around certifying the EIR and not approving the project is one that we're hoping to have an opinion on even next week. So those were the main factors. And also I will add, DD&A did, I asked about an overhead piece on that, and they are charging no overhead on that element. So it would be,
Director Garfield?
Oh, and sorry.
No, go ahead.
Erin said she might want to have something more to say if that's appropriate. Yeah.
Good afternoon, Chair and members of the board. Things are moving very fast around here. Some developments since Josh relayed the rationale for first putting the CEQA attorney under our contract. And yes, we did remove the admin fee. Holland and Knight and talking to John Giffen as well, both felt that when contracting with attorneys, they need to be able to feel comfortable knowing who is their direct client. And Holland and Knight called me this afternoon and said we'd really appreciate it if we could contract directly with FORA. So, like I said, things are moving fast. But they said, you know, the good thing is that they're ready if we get them some authorization tomorrow. We were thinking about a not to exceed for them for about 25, just to get them through giving us some legal advice on the final certification of the EIR, or the certification of the final EIR, excuse me. They are willing to come back next Friday and talk to you all about the various CEQA pathways and pros and cons of those and cost benefits. So just in what Josh was saying, things are moving fast, and we're trying to put everything in one proposal and get that approved and move forward. But I'm totally comfortable if you want to postpone the final EIR side of things until maybe consider next week after we hear from the attorneys. I just want you to know that I'm really comfortable with that. I want to know the best path forward and what we can gain from the different pathways. So,
thank you.
Thanks for that news, Aaron. That's helpful. I think then, according to what's before you, you could strike the CEQA attorney line, the 40,000, and now we're down to 83,310, and at 25,000, that's within the authority that I have for doing contracting as an executive officer, so that's an option.
Thank you. Director Garfield, did you have something?
No, I'll pass, thank you.
Okay.
I guess Josh can correct me if I'm wrong. My understanding is the Habitat Working Group wants to go forward with the EIR, and I'm a little concerned about postponing it. And what would that do to the final EIR? We need to just go ahead and authorize the money and get the EIR done. We are limited time. We have limited time, and we just keep second guessing ourselves, and all we're doing is eating up time. So as far as I'm concerned, I think I know we need the EIR completed. And we can use it for other things, and we can also use it for a lesser alternative. But if we don't have one at all, then what do we do?
Thank you. Anyone else with comments or questions? Yes, Director Ramers and then Director Morton.
I haven't spoken to anyone about this, but from what I read in the report, the Habitat Working Group has still some flexibility in deciding how they want to go forward, and that the EIR would be impacted or might be impacted depending on what direction that group takes. And is that an accurate assumption, understanding? And so my follow-up question is, then how soon do we think they will know where they want to go so that we can give them the backing that they need to have?
Yeah, so my understanding is that the certification of the EIR as currently set up is action that this board would take. So the question that the Habitat Working Group is wrestling with and has asked for an opinion from this CEQA attorney, or from a CEQA attorney, is on the legal justification and risk associated with certifying an EIR and potentially not approving a project, the Habitat Conservation Plan. But before making a recommendation, it's an ad hoc committee, the Habitat Working Group has asked to have this opinion and would take that under consideration and develop a recommendation. So that, I think, is, if we could have the attorneys next Friday, that would be a delivery of an opinion that might inform any subsequent recommendation, either that meeting or a following.
So are you saying that the attorney would be prepared to issue an opinion by next Friday, or would be there to discuss the issues? Both, okay. So that may be something that we could agendize for, if we happened to take a positive action on our next item on the agenda, and we had a special meeting scheduled next Friday, in addition to possibly, well, other items that might be on that agenda, we could put a time spot for the attorney to talk about that.
I think we could do that, and I think also, just to Ian's point, the way the contracts are written and as proposed in this board report, these are not to exceed contract numbers, so they're not saying the money has to be spent until direction is given. So if you wanted the most flexibility as a board and the most expediency in action with the consultant team, you could approve the full contracts, and we would just direct the consultants when it was determined that was the interest of the board. But that's the options.
Director Morton.
So my recollection is slightly different than Mayor Oglesby, and I would direct everybody's attention to page 14 of the staff report, which there is, after 4 meetings, that the group met and had a consensus on items. And one of those was to have a CEQA specialist weigh in and determine if we should go forward to certify the EIR, EIS by the FORA board, or would it be certified by a joint powers agreement? What's the correct procedure? So we're at a standstill. So I'm trying to understand today, if we don't take an action to authorize the hiring of an attorney, we're delaying that occurring. So today, it would seem, based on the consensus that's in the staff report, that would be the action that was requested by that organization, that ad hoc committee, correct? That's why it's in.
Well, this wasn't actually, if we got to go back to our Robert's Rules of Orders, there was no formal motion.
No, it's saying, please determine the cost associated with these proposed action and make a request to the FORA board to provide funding. So right now, agendized is that we're trying to provide the funding to meet the objectives that this ad hoc committee has outlined. One of them is to retain a CEQA attorney. I'm trying not to kick that to a special meeting, a next meeting. I'm trying to indicate that today we have the ability to do that. Secondly, we were still looking at needing additional input from other experts related to the habitat management plan responsibilities, what is the species requirements, cost of all of those things, both from an environmental advisor and also then ultimately EPS was going to take that information and run some numbers.
Right.
Which of these scenarios and which of these funds of money on your
table
PowerPoint accomplishes what this subcommittee is asking for at page 14?
DD&A Task 16, Agency Coordination and Meetings, that line item would cover Aaron's involvement and support of the Habitat Working Group.
And that's the $53,310.
Regarding the CEQA attorney, at the time, the information that we had, the recommendation here was to have this CEQA attorney as a subcontractor to DD&A. What we heard from Aaron, that she had a call from the attorneys just before the meeting.
Got it.
They were saying they'd prefer to contract directly with FORA. So, and to the tune of $25,000. $25,000 is within the assigning authority of the executive officer. So direction from the board is fine, but you need to make a budgetary approval today to still get what you're looking for, which is the attorney and the opinion next week at the meeting.
And then thirdly, is RGS now at a position that for them to continue with this ad hoc committee, and working with us, that they need an additional
And
up to
working-
30,000?
Yes.
Okay.
And we're supporting me, actually, because
Yes.
she's really a subject matter expert, where our staff is primarily now administrative at our office.
So I would like to make a motion that we approve the budgeting for an amount of up to $53,310 to Denise Duffy and Associates, and up to $25,000, what was the attorney's name?
Holland and Knight.
For the firm Holland and Knight, as to do the CEQA expertise advice, and up to $30,000 for RGS to continue the work
As described.
as described at page 14 of the staff report in support of the ad hoc committee's needed information and fulfilling their functions.
No, okay.
Isn't that?
There is a board report specifically on this item, 8D, it's 8D, and there is a scope of work described here for RGS. Looks like
It's
page
page
110.
110.
Thank you.
Yeah.
Just, could I comment on the motion? What I'm worried about, Josh, is that the 30,000 is not going to be enough. You're just, I'm absolutely serious about this.
I'm needy.
I
No.
would think that we should put in a higher number, a not to exceed number, closer to, 50 or 100, so you've got the leeway not to have to come back to us if you find that you've got Kendall working 24 hours a day, just because I
Well,
think.
I don't think Kendall's going to fight you on that, but we went through, they requested 30, and look, I'll come back. I don't mind coming
Okay,
back. So,
all right.
so I appreciate it though, Mary, because the support is important right now. We're doing a lot.
I don't have a second.
So there's a motion on the table. Does someone want to? I was just asking if there was going to be a second. Yeah, okay. So we have a second. Oh, so actually now we do have a motion on the table. Yes, Mr. Oglesby.
Two quick things. I thought Director Adams made a good point. It's not the question about whether you would come back or not. You'll come back. If we don't give you the money, you'll come back. But at a certain point, we need to realize that if you're saying this person is becoming semi-staff, then we need to allow you the expertise to tell you how far the $30,000 is going to get you. There's no need to come back in 30 days or 40 days, whatever that money is. So I thought that was a good point. It's just, I just thought it was a good point, and we shouldn't just poo-poo it because the executive director say he can come back. Then again, I want to go back to, we need to go ahead and firm up the EIR, and I just want us to stay focused on that completion. If you guys are talking about postponing it for a while, but we can't take the eye off the EIR. So right, it was. So just, I'm just throwing it out there so we just make sure we don't lose it, because if we look up and we're behind, how do we recreate that momentum? And where are we stopping at? Are we stopping the middle process? And my last point is, my understanding is some of the work was done, some of the cost overruns in a sense were came about because they are doing work on the habitat conservation plan. So you know what I'm saying? Some of the money was overlapping, and so that's why they need more money for the EIR. So to me, we shouldn't be, it's already done, but if we're using that time to do habitat management, which is important, then I don't want it to seem as though we're spending a lot of money on the EIR. It's not. We wanted it done. That's what it costs. So.
All right. Yes, Director Garfield.
Picking up on a couple of points, is it coming back for more money later, postponing something, still has cycle time? And so is it reasonable to say we want to approve those EIR expenditures subject to the need for them, rather than waiting to come back and we have a meeting and then we don't have a meeting? And so on the motion, would you consider a friendly amendment to include the things that are up there to postpone, is to in fact authorize funding subject to the executive director's receiving authorization upon input from the Habitat Conservation Working Group?
that's a lot of discretion. I'm okay. I'm okay. I want to get this done. But
Bingo.
the point is, the Habitat Conservation Group has been advised there are adverse consequences that may occur. Nobody knows. And we're trying to find that out first. So my motion was not to spend $322,000 that none of us have been advised, is it beneficial, is it not? Clearly, if it's beneficial, all of us want it to happen. Nobody's disagreeing, but we need the attorney to happen. So your friendly your amendment to pay what's needed, but it can stop based on the executive director listening to the ad hoc committee. I know this, I'm trying to understand your motion, that's fine.
Thank you. That's the essence of it, is
Okay.
let's not delay the process.
Director Gagliotti and then Director Hoffa.
Yeah, I appreciate Director Garfield's friendly amendment, because that's exactly how Delray Oaks would definitely like it. I would love it to just streamline the process. If we need it, if Josh has the authority to do so, then go do it. But I also recognize, there's no reason to spend it if we don't need to spend the money. So I appreciate that. Thank you very much.
Two questions. One, by adding the language about the ad hoc committee, does that complicate things since the ad hoc committee is not an official committee? And then, so that I guess would be a question for Mr. Giffen. And then for Josh, if the funding as proposed in the original motion, if this passes, are you comfortable that you have the authority and the funding you need to move things forward, as Mr. Oglesby's been saying? We all want to do that. So two questions.
Let me understand the first question.
So the authority was limited to the director in consultation with the Habitat Ad hoc Committee. The Habitat Ad hoc Committee is an ad hoc committee, so that seems problematic, but
I think the board, it's within the board discretion.
Danger, Will Robinson. Because the EIR, FORA currently is the lead agency, right? So if you're going to move forward with a final EIR, that is a board decision. So what you'd be looking for is feedback from the Habitat Working Group advising in the same way that the admin would, but you would not necessarily want to give the Habitat Working Group the trigger for moving forward with the EIR to final. So I would suggest that the friendly maker make it friendlier to the FORA board, giving direction to move forward with the final EIR.
Yeah.
Just a point is that from what Kendall has said, the FORA board will have to approve going ahead with the EIR and can at the same time approve funding necessary to proceed with that. I withdraw my friendly amendment.
Thank you.
Thank you. So any other questions, comments, any further
yeah,
discussion?
the other question was to Josh. So the original motion, are you comfortable this gives you the funding and the direction that you need?
Yeah, I think if we have task 16 and the RGS support with my $25,000 assigning authority for the CEQA attorney, I think we can move the ball, come back to you with a need to hear this EIR question, and at that time you can approve any additional expenditures for the consultants. Okay.
And that was my motion.
Excellent. Yes, back to basics. Any public comment on this item, on the motion or the discussion? All right, I'll bring it back to this board. We do have a motion. If there's no further discussion, all those in favor of the motion, please say aye. Aye. Any opposed? Thank you. Passes unanimously. All right. And then we will move now to business item 8E. This is a proposal to schedule some special board meetings in case we need them.
What time?
Yeah, so there's a lot of meetings on this list. This is our regular schedule here. We're proposing that we set up a second meeting each month that we can use or not at the discretion of our agenda progress. We do know that there's going to be a fair number of complicated agreement type items coming forward, and we've been learning a lot from January's meeting, and so we wanted to have this option on the table. So it would be the third Fridays, which would follow an administrative reset from the Habitat Working Group meeting. So from 1 to 3 would be the proposed time. Hopefully wouldn't need all that time, but maybe we'd be spending so much time together we'd have lots to talk about. These can be canceled if no actions needed at the prior regular board meeting, and that's the proposal. The executive committee considered this today and is voted unanimously to support this proposed schedule, subject to everyone's availability. I know it's asking a lot, but I think the next 4 or 5 months are going to be some consequential months for the transition of this agency.
Thank you, Mr. Metz. Any questions or comments? Yes, Director Ramers.
I'm willing and will certainly schedule these meetings. I'm not a morning person, so this is an unusual request for me to make, but I wonder, since the Habitat group is meeting at 10 o'clock, would this group be willing to meet at 8 or 8:30 and then blocking the entire mornings for FORA meetings rather than the middle of the afternoon, which I find more problematic for every schedules?
There's a question for us. Good. All right. Any reaction to the proposal? Any other comments or questions? Yes, Director Garfield.
I would really like the earlier time period, and my concern is that I don't know how long the Habitat Conservation group is working, but if you're working from 10 to 12 and then you have to go away and then you come back at 1 o'clock, that really much chunks out your entire day as well. So I'm in support of early. We've got a deadline, we get it done, and then the Habitat Conservation group picks up at 10 o'clock.
What was the suggested time?
8:30.
So is an hour and a half sufficient time for a meeting?
8
I'm
o'clock.
concerned. I can't do 8. So I'm in favor. I would like to make a motion that we approve the proposed schedule as outlined on page 113, and the meetings be as the executive committee recommend, 1 to 3.
Okay. Is there a second to the motion? Second. All right. There's a motion and a second. Any further discussion? Any comments from the public on this? Or we take any
May I
action?
comment
Yes.
on my motion too after they're done?
Yes.
Just a point, on page 113, you have the proposed schedule. It doesn't say on this page 1 o'clock, it's set on the PowerPoint, so you just may need to clarify that in the motion.
I thought I did,
Okay.
because there was no time.
Thank you. Yeah, it's on the preceding page, but always good to have it explicit on the page itself.
Thank you for using my word.
Yes. All right, so we do have, we'll close public comment, and Director Morton wanted to comment on the motion.
So not only do I want it in the afternoon because 8 o'clock is impossible, but most importantly, 10 to 12, this ad hoc committee works extraordinarily hard. And this ad hoc committee is going to be providing so much of the information that will probably impact the decisions this board's going to be making between 1 and 3. So I'm trying to have the benefit of that collective information being able to be brought to the action that this board needs to take at these special meetings. It seems like it's a smarter execution of time.
If I might just add from the staff perspective, there is a fair amount of setup involved in preparing for the meetings and then decompressing and resetting for the meetings. So it would really, to the question of going away and coming back, that we initially considered, having the meeting begin right at 12 o'clock, but not only would that, just complicate things from a kind of human level of food and all of that, but just the administrative kind of reset of the whole thing. is not insubstantial. It would be, I think, staff preferred 1 to 3.
So we just need to work really, really hard to not need those meetings.
Yeah.
All right, so any further discussion on the motion? Let's see, we'll give this a whirl. So all those in favor of the motion, please say aye. Aye. Any opposed? Thank you, that passes unanimously. Thank you very much. Now, this is the public comment period in our regular meeting. Are there any members of the public who would like to ask a question or make a comment to this board on items not on this agenda?
Ron Cheshire in a more jovial mood. You know,
how can
you can take 5 attorneys and you can have them write on any subject or so, and there's going to be different language, I guarantee you. And I guarantee you this: I've seen judges interpret the law differently too. Sometimes subject to whether they had a good night's sleep, good meal, and whether their spouse gave them a good or bad time the night beforehand, okay? I have seen judges rule against the law, okay? So language is very important. It's important, the intent of it's important and such, and it's too bad that we have to argue over it, but that's what happens. What's so important about what's taking place here in these last 6 months, or last 5 months now, is the fact that you are making decisions, and deep down in my heart, I know that Seaside's the LRA, and they're not required to enforce the reuse plan. And if the implementation agreements that now exist are null and void, somebody's going to stand up and say, gee whiz, we don't have to do anything that we agreed to? Oh boy, that's good. Okay? Of course, we know that there are covenants on the land and such. We're looking at how that land transfer process is going to take place and how it's going to affect us down the road. Because it's important. It's important for working people. It's important for everyone in your communities that you represent. That the jobs, the opportunities that are created as much as possible, as much as practical, can be maintained in this area, okay? Lastly, I want you to know that as Training Education Director of the Monterey Santa Cruz Building Trades, we have submitted a $900,000 grant to the state of California, the SB1 funds, that gasoline tax that everybody likes paying. They put $25 million aside for training, because in providing new infrastructure in the state of California, we need a skilled, qualified workforce to be able to do that. And we are going to try and identify 155 individuals over a 2-year period of time to basically go ahead and get into apprenticeships, to become skilled, qualified individuals to work in and around your communities in other places. So I will be coming to you individually, probably, and I would appreciate as much cooperation as possible, and that's it. So anyway, thank you very much, and thank you for what you do. You know, really, thank you for what you do, but remember, is the public has to know also, and sometimes the public does get frustrated.
Thank you. Any other member of the public wishing to comment on items not on today's agenda? All right, seeing no one coming forward, I'll close public comment. I will just mention that for our special board meeting next Friday, so far it looks like the only agenda item will be the second vote on the ESCA LRA issue that we talked about today. So with that, we are adjourned.